On Thursday, the U.S. Supreme Court made another monumental ruling in favor of Obamacare this time. Under the decision, the federal government may continue to provide nationwide tax subsidies to help eligible individuals and families buy health insurance. David, what are your thoughts, and how will this affect Colorado? Well,
it won't have any effect on Colorado at all, because the Colorado legislature, in a bipartisan way a few years ago with House Majority Leader Amy Stevens, passed a bill to set up a Colorado health care exchange. And the governor signed it, and we had a big public debate on it. And I realize that's kind of a strange thing to be saying about something related to Obamacare, that it was actually done legally, publicly, and according to the proper procedures. But that's how we did it in Colorado, because I guess we're a little different sometimes. The question was, what about the states that had rejected setting up a state exchange? Can the federal subsidies go to them? The Obamacare statute says an exchange established by a state, which seems to mean established by a state rather than established by a state or by the federal government. And in fact, that's how the architect of Obamacare, Jonathan Gruber, repeatedly described it, because he said this, saying we only give the subsidies to the states that set up their own exchanges will be very powerfully economic coercive in forcing states to do this. His prediction turned out to be right, but the intention was clear. There is an alternative statutory interpretation, which ultimately Chief Justice Roberts relied on, which is an extremely roundabout and complicated way. I won't say it's crazy or ridiculous or frivolous, but it is highly strained compared to simply reading established by a state as meaning established by a state. But Chief Justice Roberts, as he did in the previous Obamacare case, has, although he's promoted himself as the umpire who just calls the balls and strikes, when Obamacare is up to bat, he sure changes the strike zone to make sure Obamacare gets on base.
This can be open to a variation of interpretations. Craig, what do you think?
I'm worrying about the breakdown in the rule of law, because I think it's a strained interpretation. Jonathan Gruber made it clear, and Obamacare made it clear. They wanted states to participate, set up an exchange the way Colorado did, and they said if you don't do it, then your citizens are not going to get the subsidies. And they thought all the states would fall in line, but a lot of states didn't. So maybe Colorado was the sap and the sucker. Why do we set up an exchange when these other states that didn't do it got the benefit of the subsidies anyway? So I think the Chief Justice realized that, wow, if we undo Obamacare, it's going to be a big mess. So he went for this strained interpretation. And really, it inures to the benefit, I think, of Republicans, because if the decision would have gone the other way, there would have been a lot of people mad. Same with gay marriage. It kind of gets it off their plate. And so I think the Supreme Court, even though conservatives will complain about these two opinions, when it comes to electoral politics, I think both were in their favor, because, like it or not, we have to accept gay marriage. Like it or not, Obamacare is going to be there until and unless it's replaced by another Congress with a president who will sign it.
I mean, when I think of this topic, I think of how it relates to people at a personal level. I'm not sure. What are your thoughts on this?
Well, sure. I think that from a personal level, it's healthcare impacts every single one of us, and being able to have access to healthcare is, I think, critical and should be something that every single member of Congress wants to strive for. And interestingly enough, the Denver Post made a very interesting point, I thought, in an editorial this morning about the ruling, pointing out that actually the Supreme Court might have very well saved the Republican Party from a very embarrassing PR disaster in its ruling, because the Republican Party, for 8 months as this case has been working its way through, has not come up with any sort of meaningful options or, replacements for Obamacare, as has been the case since Congress initially passed it. And I think that the ruling really does establish that Obamacare, the Affordable Care Act, is the law of the land. So let's get down and start working to figure out how we can make the system and the law more efficient, more effective, and more affordable.
I know some have said that this almost secures that Obamacare isn't really going anywhere anytime soon. Natasha, what do you think? Can you wrap it up for us?
I think that's the case. I don't think it's going anywhere soon, but as we've been discussing at this table, it certainly needs tinkering. And it's time to get down to business and do the tinkering that needs to be done to make it a stronger and more effective system. You know, I think that this lawsuit, as a writer, for me, was very interesting because it comes down to a matter of words and an intent of what the writers were saying. And I agonize over everything that I write. And I look at that and I'm like, wow, if they had a do-over, they'd probably take that little clause out and change it. Roberts, interestingly, goes with the intent of what the legislators were trying to do rather than the actuals, specifically what it says. And Roberts, you know, with this decision, but throughout his tenure, he's a little more robust than or controversial than some of our previous justices. And I think he's starting to set the tone for what his tenure and what the tenure of his court is. There's a flexibility of thought, which could be upsetting depending on where your politics are, but I think it ensures that this week has been very exciting with the Supreme Court. But I think in next year could be just as exciting as well.